state officers and let them know that nobody has responded. And then let the state deal with it in whatever way the state is going to deal with it. I'll get mine.
David?
All right. Under Illinois non-profit law, you run into a quandary with this one as a being board of directors. Until such time that the other elected delegates are certified and actually do something to say they are, because you can't just appoint somebody to a non-profit in Illinois without their approval. So without that approval process, which one of the 6 delegates for Illinois would continue being the delegates if only 5 responded? You're getting into a legal quandary way beyond just did they not, are they, you're getting into a certain points of time, who's the official delegate for the board or for the corporation. Additionally, you're getting into a lot of other legal realms with that. So,
David, I know it says and qualified. I didn't find the word approval in the Illinois statutes.
No.
With me later.
no, right. In order to be it, they have to be qualified. But under Illinois law, and also the court rulings have been, you can't just sit there and say, well, today I'm going to appoint you a new director of this property. You have no knowledge of it. There has to be a system, and this is common basic, common sense, which most laws are based on. You can't sit there. But you cannot have people appointed to a position like this without their knowledge of it and put them into a position. I mean, you sit there, the Illinois substation, which put me into it, right? And all of a sudden, someone wants to sue the corporation, and my name's in it. What's the first thing I'm going to do? I never was in this position. I never agreed to it.
Well, I think, it's always been assumed that when the states appoint people, they notify them. And they're pointing them out.
And what's the first thing to assume?
Sometimes, of course, there was an election procedure, and then we would announce the results, even the chess like delegates call.
But put the onus on the state to say if you're the one appointing them, you ensure that you have their approval before you send it to the office. It's very simple check and balance. That should be done at the state level, not the USCF level.
I believe under Illinois law, if someone is appointed and they fail to accept, the previous delegate is still in office until such time as the delegate. Now, in New York, and I believe it's not too much different from the rest of the country, most of the people that were appointed, really the overwhelming majority, everybody but one in New York, they were already delegates. So when they did not respond, legally, they still remained delegates. Now why don't we, if we have to have this requirement, just say it applies only to new people, because the other people really, whether they respond or not, they're still delegates. That would save everybody a lot of trouble.
Bill, to be a director of the corporation, is it really so much to ask for a 10-second email saying, I accept?
Yes, obviously it is. That was our
Harold, if they were to continue being the director by not responding, right? If they were a director last year, they didn't respond this year, but they were nominated for it. How long did they serve? Under Illinois law, there's
the Illinois statute says the director continues until their successor is chosen and qualified.
And there's
now, obviously, the acceptance provision would add to that qualifies, that we have wording to the bylaws to add and qualify to conform if you keep acceptance. But again, we're on the basic issue of whether we have acceptance. Bill's position is if you do want to keep it, he would modify it and only apply to some people. But I think that should be raised secondary.
There's wording about
right
until the next board meets. When members meet, when delegates meet, right, if you have an open position, it expires at that point.
Yeah, we have provisions fulfilling open provisions at the meeting.
Right, so this, what Bill Goifer is saying is not that they would not serve the full term. They would only serve until such time that the delegate meeting. They would no longer be a delegate.
let's hear from Brian.
I mean, I think we're all wrestling with the fact that the board of delegates is the board of directors of the corporation. And Bill Hall has made an excellent point, which is when someone becomes a director of a corporation, a lot goes with that. The corporate veil is not 100% impermeable. It can be pierced, and the directors of the corporation can end up with liability. In some cases, fairly serious liability. And the recent trend of legislation has been to expose corporate directors to more liability with laws like Sarbanes-Oxley. And I think that trend will probably continue. So it doesn't, in that environment, it does not seem unreasonable for the board of, when someone becomes a director, for there to be some positive event which makes it clear that that has happened and that they have accepted the consequences of that. You can't just show up or not show up. On the other side, many people, David Heiser, for example, are arguing that, Bill Deutschberg as well, are arguing that this section creates a lot of bureaucracy and craziness. But the reality is that we have that craziness in our structure already, which is 150 people being the board of directors of the corporation. We're in the process, I hope, of changing that. So what I suggest is that I'm in favor of just leaving this alone, leaving this question alone, pending the outcome of the other discussions about whether the board of delegates is the board of directors. If the board of delegates is the board of directors, then we need more than this. We need something that makes it where the delegates will accept accept their position and accept that they understand what is involved in that position. If the board of delegates is not the board of directors, then it really doesn't matter. It's an annual meeting of the delegates, and they just show up, having been sent by their state affiliates. Either way, we don't need this section. But what section we need depends on what we decide about the other issue, which is really the paramount issue for us, for this body.
Alan?
I think that what we're doing here is kind of putting on a pair of suspenders along the belt to make sure that, depending whether or not, I tend to agree with you, the GTF proposal were to pass this year, which I think may be unlikely. If that were to be the case, then this sort of moves out the question. It does, however, create a situation where we don't know necessarily who the delegates are. I think we still need to do that. All we want to do, right now, there is no time frame around it at all. And all we want is this time frame on it. The other thing that did come out of the state's meeting was moving those dates. Instead of March 31, maybe January.
Yeah.
At which point, then the office would respond back to the state affiliate and say, we haven't heard from your people. And let the state come back with the list with the accepted stuff. But the onus back on the state at that point to provide those lists. And I think we put an April 30th date on it. Tony Payton wanted to make it April 31st. But we figured out.
I'm not going to go with that.
So we made it April 30th. So there is some alternative language floating around. I get what you're saying, right?
Should be April 1st. Does anyone else?
April 1st.
Go ahead, sure.
The 10 people that were selected in New York, were they all at the meeting?
No, most of them were.
Okay, so they knew they were appointed as delegates.
Well,
or selected.
Even the ones that were not at the meeting, they were all, except for one, already delegates. So, I mean, maybe they didn't think about it, but I think since they knew they were delegates in the past, I don't think any of them thought they'd been replaced.
Okay.
Okay. I said New Hampshire first, and then back to Brian.
What David says is not entirely true. When a delegate does not show up for the meeting, is not automatically stricken from the delegates list. Only if there is an alternate delegate available to replace him.
That's correct.
That's not completely true.
No, I don't think you're correct. He's not there by 9:30.
Last year, the
That's
bylaws
acceptable.
were amended to provide a provision that if you don't show up by 9:30 on Saturday morning, you have been deemed to have resigned.
Unless you gave notice that you would be getting there later.
I think that works because you also went to a one-year term.
Right.
Right.
All right, let's see, gentlemen, all the way in the back, I'm sorry.
Clarify what I said, since it was incorrect in the statement attributed to me.
I'm sorry, what they did?
This statement attributed to me was incorrect.
Okay.
Now, clarify, I did not say the delegate that didn't show up ceases to be a delegate. No, what I said is someone who's appointed to a position, right? Or in the case of, like, Phil said, that someone who doesn't respond, was nominated but never responded to accepting the position, is considered an appointment. And at such time that the next board meeting meets, that appointment ends. That's what it must do. So the delegates that did respond would continue whether they elected or not, or showed up or not. It's the appointment.
All right, gentlemen in the back. Please give me your
Mike
name.
Mulford, Georgia.
What?
Mike Mulford, Georgia.
Oh, from Georgia, right.
It seems to me that New York's experience really proves the justification for the acceptance provision. The acceptance provision was not just so that we at least ensured that people knew they had been appointed. It was so that the people who were officially delegates were people who had demonstrated that they cared enough to at least send one 10-second email saying, yes, I accept. So the fact that the delegates who were appointed in New York chose not to do that indicate one of two things. Either they didn't care or they thought they didn't need to because they were already delegates. I don't see anything here that tells us that we don't need the acceptance provision as long as the delegates are the board of directors. It's just we need to have, what we've shown is we need to have the hard deadline as in the ADM.
All right, well, Beatrice, then Myron, and then let's take a look.
Yeah, I would like to say that I believe that in general it's a good concept. If the delegates are directors of the corporations, they should be more diligent. But at the same time, somebody mentioned the word system. I think the office needs to have a better system. Maybe notify them through email and have people confirm it online. So you can email them a link and they can just go to the website and enter their own information, confirming that they received the communication.
I would
That
say,
would make it a lot easier.
from my point of view, if we keep this, I think the onus is on the state chapter. And I think if you're naming people at your Labor Day meeting, damn it, you have a form, get them to sign it there. Or get them to a computer and have them email acceptance right there. Again, I personally find the acceptance provisions more problems than it's worth, but Myron.
Even at the simplest, most basic elections, like in a local club, even in a school office, people are sometimes nominated for a position, and right then and there, they can say, no, I'm not interested. And as you get into a situation like USCF has, you have two problems. One is that in many cases, delegates are named by the state, and they may have said something informally, but who knows, they can always change their minds. In some cases, they may not even know they've been nominated. They may not even know they've been appointed. They don't have the ability to say, sorry, I don't accept. So whether it's an acceptance or whether it's USCF saying, hey, do you accept, whatever the situation is, they have to have a right to not fill the position they've been nominated for. Now here's the problem. The problem is that they're nominated by the state, but USCF is affected more than the state is, much more. USCF needs to know who is on their board of delegates, not just for election purposes, but purely to function. So USCF has to be involved to some degree in order to make came from the state are indeed qualified and willing and able to serve. Now, there may be a number of ways of doing this, but it has to be done one way or the other.
And Myron, I think that you hit a good point. One of the problems we have right now, the current system has no structure to it at all. And we are simply in here trying to put some structure to it and putting a time frame on it.
Exactly.
And then giving the office a person to contact and say, what the hell's going on? And I do want to address one little thing about, you know, our colleagues in New York. If us in poor little backward Kentucky can actually get our delegates to respond to the office, surely in sophisticated New York,
Did you even get internet yet?
yeah. They replaced that string in the can. It's cool, you know?
Y'all got an indoor plumbing up there?
Yeah.
Can I ask a question?
Question.
How do we confirm the acceptance by the executive board members? What is the process? The executive board members are elected.
They have to submit petitions to run.
They have to submit petitions to run.
That's pretty much
Actually,
implied,
plus
except
they-
And they have to either sign their own nomination petition or acknowledge the nomination petition before we promote that.
Okay, good. All right, before we vote, Jim, and let's vote and then Mr. Gray from Oklahoma.
As much as I originally abhorred this whole, what do you call it, acceptance business, the more I think about it, I don't know about the rest of you, but when we this past year elected our delegate, we didn't talk about the possibility that, oh, by the way, as a as a member of the board of directors, you might remotely so, but nevertheless, you might be exposed to all kinds of things. That wasn't discussed at all, such and so even if your elected delegates are there at your state meetings, I'm not sure that would necessarily have been conveyed to that person first. Second, Bill says that Illinois says that the delegate, if something goes awry, the previous delegate remains in place. Well, this is a relatively new issue for USCF, this board of delegates. And so if a guy's been there for 20, Roger Gotcha, maybe he don't want to be delegate anymore, thinking that another delegate hasn't been appointed, not realizing possibly that, that he might be exposed to something brand new and potentially serious. And so I disagree that it should go to only the new delegates. I think it should go to all.
All right, I think we're ready to vote.
Can I ask a question?
And then move on to the delegate. Yes, Messenger.
Yes, are we voting on this, the acceptance as amended, or?
Well,
amendment?
no, we're just voting first on whether to keep the acceptance. And by the way, this only makes sense if the delegates are directors. If at the delegates meeting they vote differently, then we will provide and bring up the leading back there because it would go for directors, which will need. But it's also possible this will be a 2-year process rather than 1 year. So we do want to vote on that for now. All right, just the principle of keeping the acceptance, and then we'll discuss if you keep it, you know, should there be deadlines. All in favor, raise your hand. You want to count that up?
Yep.
1, 2, 3, 4. Okay, that's 19. All those opposed, raise your hand. 1, 2, 3, 4, 5.
Two on myself.
Oh, I'm sorry. Let's try that again. I might have counted both sides. 1, 2, 3, 4. You're not voting now?
No, I didn't.
Okay,
I voted
4
in favor.
abstentions. 1,
3. 3 total.
Okay, so now that we're there, we look at ADM 1114 on page 17. And as Alan indicated, there are 2 versions. Our original version from the committee, which the committee liked, is we wanted a deadline to encourage people and to help out the office. And we originally were proposing March 31st. At, I guess it was the state's workshop, see the state's workshop or our committee, I think it was state's, people said, well, March 31st is still late for the office. So why not make it January 31st? And you say about resubmitting, let's give them a deadline on the resubmitting. So we came up with, instead of March 31st, it would be January 31st in the first sentence, and the second, at the end of the second sentence, you would add by April 30th. So the state would have two chances, the ability to do it without waiting for meetings, one by January 31, the other by April 30th, and the hope that giving these dates would encourage people to get their acceptances in, because having no dates just seems absurd to us. Discussion. And I would say we're on the January, March version, January, April now. We can take votes on each of those deadlines. Brian and then Bob.
My opinion is that it doesn't make any sense. If the term for the delegates, that is the directors of the corporation, starts on January 1st, then having as a deadline for accepting their position March 31st. What's their status between January 1st and March 31st? Who is the delegate? Who is the delegate?
Excuse me, we accepted the change to January 31st.
Okay.
Well, and I think the problem is
It still creates a problem.
Because states name late. They don't name for November 1st deadline. Some states might not name until the end of December. And so if you say December 31st, you're setting up a failure.
Minnesota names February or March.
Pennsylvania did not name until July this year after I kept problem them. And Ohio never named for the rest.
I don't know that that's the critical issue. At the state's meeting, somebody said, well, we shouldn't have it December 31 because that's around Christmas. And I'm like, big whip. The term starts January. If the state doesn't get around to naming it later, the state doesn't get around to naming it later. There's a whole lot of states that are naming it. Kentucky named their delegates for next year last month, because that's when we met. So it is what it is. If the state doesn't bother to do it till late, I don't think that removes the onus of giving the office a point in time at which they contact the state and say, we haven't heard anything. So you got a deadline, I think you got to have a deadline of when the damn terms.
We can take a strong vote on December 31st for January 31st. Harry first, and then Bob, and then Bill.
I would just agree that it ought to be January 1 and December 31, whichever way you want to phrase it.
Because January 1 is a mail holiday, we can accept by email. Bob?
What I would favor would be when the states submit their list of names, that should be with the acceptance. If you get the state.
That would be the best way.
Right.
That's what I hope we have. Yeah. Bill?
Yeah, I agree that January 1st makes sense because really the deadline is to the benefit of the office. Tell the office, you don't have to bother contacting people anymore. The deadline doesn't really affect the state all that much. If you have a problem like we do in New York where certain people don't ever respond, but yet they do come to the meeting, well, they can still not respond and come to the meeting. So it doesn't really hurt us to have an early deadline. So
all right,
I make the deadline early so it's easier for the office.
Strong vote, January 1 or January 31st? All in favor of January 1st? Raise your hand. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11. On this side.
9.
12, 21. Well, all in favor of January 31st, raise your hand. 1, 2, 3, 4 total. Fine. Yeah. Any abstentions? 2. Okay. All right. We'll replace that wording then by January 1st. How about April 30th for the second deadline?
Why do you need a second deadline?
What's the consequence of not hitting
There's
the
no
second deadline?
consequence if you ignore it. I think all you need to do with the second deadline is the office will feel obliged to do more work, and we don't want that.
At the second deadline, the office calls the state again and says,
Yeah, we don't want that. One deadline.
Well,
Bill, you asked what the consequence of
Okay,
it was. The consequence of it is another point in time that the office contacts the state officer to say, we ain't heard from you yet.
The consequences,
That's
Bill,
exactly what I want to
they will deem to have been resigned, decline their selection, and the state chapter shall resubmit a selection accompanied by acceptance. And that says when the selection is made the second time, the acceptance has to come with it. Mike?
I think in the case of either or resubmitted appointments, there ought to be a voting deadline of, say, 30 days from when received by the office.
Then you got the office having to track them 30 days from.
That's not that hard to do. If we know when we got it, we know when 30 days that should be. I think that's probably easier than setting a deadline. As pointed out, we have several states that don't and can't submit their lists until after December 31st. There ought to be, I'm not sure under the current proposal what deadline applies to those.
Under
They're
this
stuck on the
proposal,
same deadline as everybody.
Yeah, well, in that case, that deadline would be December 31st, could be several weeks before the nomination was even received by the office, which is absolutely asinine.
no, because we don't know, the office doesn't know what the state is doing.
That's the whole point.
So the point is, the office is responding and saying, we haven't heard from y'all yet.
If the nomination comes in late, or if it's a resubmit, which we know we're going to have, from somebody who didn't respond and therefore is stricken from the list, there ought to be a deadline for when it's received, not some particular date.
Deadline is 0 days.
Well, not that.
Wait, what's on the floor right now?
By the state when they send it in.
What's on the floor right now is the second part of the proposal. So in other words, what if you miss the deadline? The consequence is they'll be deemed to decline their selection. I don't hear any controversy about that part. And then we thought, what does that mean? It should mean that the state chapter should resubmit a selection. Now, the only alternative would be that the alternates take their slots if the alternates have accepted, of course. Mike Atkins.
Pat Smith had said several times in the first couple of days that the office really wanted a second deadline.
What's that?
Pat has said several times in the last few days that the office wanted a second date.
That was my impression. Georgia, Mike Alford.
Seems to me that the proposal gives you the deadline for the second date because it says it must be accompanied by acceptance. If
We
there's
want
no
to make
acceptance,
it
they haven't nominated anyone else.
Right. And Brian, and maybe and David, and then we'll go.
Which proposal said that? Because what I wanted to say was, why can't we cut the Gordian knot and simply say that appointment by the state affiliate is defined as submitting the name along with the acceptance letter from the person.
Exactly. If they haven't submitted an acceptance, it hasn't happened.
And then we don't have to discuss deadlines for non-acceptance and what happens if they don't, and then what's the second deadline if the non-acceptance, et cetera. An appointment by the state affiliate means that the state affiliate submits a name along with an acceptance letter signed by the appointed person. And the acceptance letter should be a form letter provided by the office so that the signature on it represents an agreement by the appointed person that they understand what they're appointed to.
Maybe we can't do it by email.
Yeah, I would rule out
Well, email is fine too, but the form of what they agreed to should be spelled out because these are people who are accepting responsibility as directors of the corporation, carrying with it significant liability. So they should be understanding that they are accepting appointment as directors of the corporation.
All right, what about Brian's idea, which I guess is sort of a form of agenda? What's the feeling on that?
Yes.
Taking the second part of our thing and putting it up to the first, because that's the way we have the second part.
And then we can drop all of the deadlines, because the state affiliate is either appointed to or not.
David?
One thing that since the delegates are appointed by the state,
Yes.
at any point in time, the state association can reappoint a new slate of delegates at will.
No.
No.
Not unless the delegate resigns.
Unless the delegate.
But it's a appointed position by the state, so what how does Illinois law, because normally under Illinois law, you have to, if it's an elected position, the members vote.
It's not actually an appointment, it's an election. The state.
The state is not, it's
The
a
state.
It's a seat election.
Seat election.
The state selects, so isn't the state
States do
board allowed?
I don't think Illinois law.
different states do different.
Right.
All right, Mike.
Carol, correct me if I'm wrong, but under Illinois law, a director remains a director until the term of office resigns. So once that person becomes a director, in Brian's suggestion, which I wholeheartedly agree with, the state sends in a list and says these people have accepted. On January 1st, those people are directors. They cannot be replaced by the state unless they resign.
Or die, or let their membership lapse, depending on one of our provisions.
I don't think we should let them out if they die. No.
Well, Chicago politics, but anyway.
Alan, you're not even on yet. You're looking at
All right. Brian has given us a counter idea to, in effect, take the second part of our proposal and move it up to the first part. I still think there should be some deadline somewhere, out of fairness to the office. People who, well, no, not the Samsung problem doesn't exist for this, but it may be important at some point to know who the delegates are, and there's always a possibility of this person's delegates. We're going to show vote here whether we would like Brian's idea moved up to the first part of the initial process. As you're keeping acceptance comes with submission of the list.
So just to spell out, if I understand what you're saying, the way you're interpreting what I said, which I is that, turning to page 30 of the call, section 4, we would drop the second paragraph of Article 5, section 4, and we would develop some different wording for the first paragraph that would embody the notion that I just put forward, which is that appointment by the state affiliate includes evidence of acceptance by the person who's been appointed.
That's what I think we're considering.
Yes. Okay.
All right.
I agree with that. Okay.
All right, Gerald and Mike, then we'll vote on that. If we vote no, we'll go back to where we were. If we vote yes, bylaws with Brian's help, we'll work on wording before delegates. All right, I recognize two people, Gerald, and then was it Bill, or not, Gerald and Mike.
The real effect of this is going to be that the delegates next year will be the same as the delegates this year. True. Okay. As long as that's understood, that's fine.
Because you think the states won't have time to...
I don't think the states will submit a list and acceptances. No, I do not.
If that's the case, then I think you should
You've been
vote
making
no.
a really good job of making sure that Alan.
Harold, you said something about deadline. I'm not entirely clear what you meant by deadline, because under Brian's proposal, there is no deadline because the acceptance has to come with the nomination. The only deadline I can come up with is a deadline for the state to submit the dog list in the first place.
Yeah,
and that's not currently on the floor.
Right, that's November 1st.
November 1st would still...
No, that's a due by, it's not a deadline. There is a minor difference.
Yeah.
Oh.
Yeah, and
Does the state chapter shall designate, must designate by November 1st. Must designate by November 1st or as soon thereafter as feasible. Got that?
That's why due by not a deadline. There is no or else.
All right, Bill.
I'd just like to respond to what Gerald said. I think in New York, the effect of this would be, after we name our delegates, hopefully, if we remember, there'll be one sheet of paper, and we'll say, hey, delegates, come sign here, second and seventh.
That'll work.
Yeah. One sheet of paper will be sent to the USCF.
Right.
However, the people that we name that are not there will make no further attempt, and they will just want to be delegates, show up, and we'll vote. I think that's what will happen.
All right, voting on what we want to call Brian's basic idea, which I think we understand. If this workshop favors it, Brian will meet with members of bylaws, and we'll try and have something for floor, because we want to have it typed up and give it out to them. All those in favor, raise your hand. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11 on this side.
11.
Okay, that's 22. All those opposed? Okay, don't on this side.
4.
And abstentions? All right, 22, 4 to 2. All right, Brian, we'll find a time for you to get together with bylaws. Just in case we do present it on the floor and the floor doesn't like it, as a fallback, can we stick with April 30th for the second day? And we put this up ahead of that and see if we could pass that idea. We would need 11/14. But I just wanted to prepare, in all instances. So we do need to move on. It's getting close to 10. All right, can we vote that if this doesn't work, the April 30th would be the second cutoff date in the resolution.
Yes, I can stick with that. I think it would be a good idea because regardless of this very good proposal from Brian, there will be a bunch of states out there. That's
And this gives the office a bogey point.
All right. All those in favor, please raise your hand. So we can move on. 1, 2, 3. And on this side?
11.
21. All those opposed? I got a total of 2. All those abstaining? 1, 2, 3. All right. Hopefully some of the other stuff will go faster as we had for GTF. Okay.
35 minutes.
ABM 1115, I think, is relatively simple. It's on page 17. If we have the acceptance provision, I'm sorry, you can get the note down. 22 yes, 4 no. No, I'm sorry. 21 yes, 2 no, 3 abstain. All right, ABM 1115, page 17. This should be something simple. It's at the bottom. If we're keeping acceptance, we should add until a successor is selected and qualified, which actually matches the wording of the Illinois statutes. So it's really a technical amendment. We're hoping we won't need much or any discussion, and we just proceed to a vote. Okay, all in favor, raise your hand. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 12 on this side.
12.
Opposed? Abstained?
1.
Okay, now 1116, that's a little bit more controversial. The currently bylaws say that to be a delegate, you must have a current membership as a preferred state of delegates. Well, as far as it goes, that's okay, but as pointed out, delegate's a responsible position. We think you should have to be a member throughout your term as delegate. And therefore, we propose saying only current members may serve as delegates. Now, what that means is, if someone's named a delegate and accepts, and is very careless about his membership renewal, and sends it in even a day late, he's out as a delegate. The counter, which I think got 2 votes, was for a 28 days grace period that had been suggested by Mike Nolan. So, think about that. And we do have Pat Smith told me that there were some people on the list here who hadn't shown up yet, who had an expiration date of July 31st and had to get renewed. All right, Georgia and then New York. Mr. Mulford.
How does the state know that their person has effectively resigned because their membership lapsed? Sounds like another bit of burden for the office to notify them, and then we get back into that infinite loop.
It's very easy to write a proposal that runs at midnight on the 1st of the month and sends notification to the member and the state chapter saying, so-and-so has to renew his member, therefore he's out.
I think I saw Bill and then Brian.
Yeah, the official position of the Federation, I think, at least with regard to other things such as gold membership, is that you're only allowed people join through affiliates. And, you know, it's not your fault if the affiliate doesn't submit it promptly. And, you know, in order to avoid a lot of trouble for the office of, well, I paid it, when did you pay it, when did they submit it? You know, by allowing the 28 days, while it's still possible, an affiliate could be even later than that, it's not too likely, so it takes care of most of these cases. I think that's simpler, and I think this motion, you know, makes sense if you use 28 days. But if you use, you know, 0 days or 1 day, you're asking for some trouble.
All right, I see Gary who hasn't spoken. I might ask someone from the office if
I drive with an expired license or expired plates at least once every other year.
So irresponsible. That's 28 days, Gary?
Yeah,
you should lose all privileges of driving.
Well, I do, but I still drive.
When you get stopped, the
How
officer
many days have you
28
served as
days.
a result of this?
No, but the
He drives very carefully. Bill?
I think it gets back to the point of if delegates are the directors of the corporation, well, you need to potentially take a more serious stance. The other thing is, like with the gold membership, and I've talked with Bill, as far as the office goes, if people have a halfway reasonable explanation that's semi-credible, we're going to err on the side of the member on something like that. With the director of the corporation, we have to be much more specific in letter of law. So it's tricky.
All right, well, there are points on both sides of this, Brian.
I mean, I think that we shouldn't be creating any pitfalls. These people are going to be directors of the corporation. They're going to submit their names to the state of Illinois as directors of the corporation. We're doing that already. The way we handle this in NACA is before you can be appointed, before you can even have your name on the ballot, you have to have your membership valid through the end of your term.
Interesting idea.
So, again, I think we should go back to the appointment point. The state should not be submitting the names of anyone whose USCF membership is going to expire during the term of their appointment.
Oh,
They should
I see what you're doing. I'd like to be recognized by that as well as by
life member or multi-year members.
Or someone who's going to renew their membership for at 1 year. I still have the floor, so I hope it's okay. So the states only appoint people who are going to be USCF members as of the date they take office as directors of the corporation until the end of their term.
Well, that would solve a problem. I saw Richard, Guy, and Mike. Richard.
Mike, in a practical sense, I think that's putting too much burden on the state. These state organizations are not hard. You're basically requiring, to install that, you're requiring that they go on the MSA site, validate things, and ask them, tell them that in addition to, you have to sign this letter, you also have to renew your membership. I feel it's an unnecessary step.
Now, can I interpret that as also, are you in favor of the 28 days? Or
Yes.
is that something? All right, I think I saw Guy next, Mike, and then Mikey.
Yes, I don't know if it puts too much burden on the state. It just means that the state should check the MSA site and make sure that, get on their delegate and make sure that he or she remains a member. It shouldn't be that big a problem.
It shouldn't be that big a problem. And again, we're coming back to
Texas, who will have as many as 12 delegates next year, can probably
that's like a couple quads.
three of them.
These days with same-sex marriages, it's hard to keep track of how many are in a couple.
But it just seems that, saying that they must be a member through their entire term, which means you have to renew now, that's excessive.
Mike. Oh, I'm sorry, Mike. No, and then Mike.
Although I have raised this issue in the past, it is worth pointing out two things. One, if there are no requirements under Illinois law that somebody need to be a member of the organization to be a director of the organization. That's quite clear under Illinois law. Second, If we are, in fact, going back to where we were before the Blue Ribbon Committee, there used to be a phrase in the bylaws that said that the state chapter was responsible for the state dues of their delegates.
There used to be such
Still is.
provision.
No, that was stricken when we got rid of, through SMOV, that whole clause was stricken.
Because it wasn't fair.
Because it wasn't fair, when the state chapter might not have even put them on the ballot or anything. I would say we could certainly put that clause back, and I know the office used to occasionally bill state chapters for somebody's membership.
Mike Neatman, and then,
Instead of being reactive and sending out an email after an expiration, which may still be necessary, why not be proactive?
Oh, I'll probably send it out every week.
Yeah, it's not something else.
I'll rag the hell out of people if I get a chance.
all right, what I'm sensing here is there's definite agreement, we need something like this. The question is simply, should there be a 28 days grace period or not? Yes. And Brian has a very interesting suggestion which would avoid the problem. But my sense is we don't want to necessarily mandate it. I think state chapter should be encouraged. So why don't I call them a vote on a 28-day grace period and see what people think. All those in favor, whoops, of a 28-day grace period, raise your hand. 1, 2, 3, 4, 5, 6, 7, 8. I got it. 9, 10. Thank you. All right. All those opposed, raise your hand. Now, we have 2 on this side. Abstentions? 1, 2, 3, 4 total. All right, I guess we'll reword it and put in a 28-day grace period. Again, part of this workshop is to make things move more smoothly at the delegates meeting.
How about a vote on putting back the clause that says the state chapter is responsible?
I like that. We can do a vote. I don't know what you got on that.
Question.
Bylaw.
Comment. I probably should have made this comment before the vote.
Dave Coons.
The comment is that providing they are a member at the time of the delegacy.
That's the old law.
That's already.
No, okay, the 28-day grace, provided that they're a member at the time of the delegacy.
Okay, yeah.
We didn't really repeal that. That restriction's already there. We haven't
Okay.
repealed that.
But no, you're talking about how we would word it.
Yeah.
Yeah.
I think the agreement is yes, you still have to be a member on the first day of
Gotcha.
delegates.
Okay.
28 days won't apply to that.
I feel strongly that we should have some new provision. Now, I don't feel strongly what the provision should be. I think that it's a bad idea to create a cloud over the status of any of the delegates. Whether there's, so either we should go with one of the ideas that Mike mentioned, which is you don't have to be a member of the delegates. Under Illinois law, you do not have to be a member of a membership corporation or a director. So that eliminates one way of eliminating the cloud. Another way of eliminating the cloud with the directors is we clear up all membership issues before they ever become a director for the duration of their directorship.
Well, I would suggest.
That's what I
would suggest that Brian's idea.
I know,
something
my
that,
idea was never turned into something that could vote.
That Brian's idea go to the States Committee for consideration because you would be the committee. I think Mike didn't want a straw vote on his thing. We could take that, but I do need to keep moving. It's after 10 or 8. Gerald.
What's the wording of what we just voted on?
If you look at, on page 18 of your delegates.
Yeah, I'm looking at it.
ADM 1116.
Right.
The proposal would change that, our proposal was to add a sentence that said only current members may serve as delegates. We got to work out the wording, but I think what we're going to do then is define current members for that provision as members. They have a membership that has not lapsed more than 28 days.
But we're going to
And
keep
leave
the current
the
wording.
sentence that says they must have a current membership as of the first day of the delegacy.
Okay.
And again, anyone who wants to assist the bylaws committee in doing this.
I mean, that's
let us know.
Yeah. It's worth pointing out that the 28-day requirement came from the voter registration process because somebody who is a registered voting member, if their membership lapses for 28 days, we revoke their registration. So this would be a similar grace period.
All right. quicker now, you could get to the
Well, it doesn't
GTF.
require very much discussion. Mike's idea is simply
Yeah, I'm going to try and take
strike,
a vote on it right now.
strike section 5, items, subsection C.
Well, Mike's is to add a sentence saying the state chapter is responsible for the dues of the delegates.
We don't need to strike it, I think we just add a sentence to the state chapter is responsible.
You know what Mike is proposing?
But you mentioned two different things, so I'm referring to a different item.
Okay.
Yeah, let's do a show of hands
It's a
on it.
little unclear. What you mean is when the names are submitted, in order to have them, have the count, the state has to pay. But do you also mean at some point in the middle of their term, when it expires, the state has to pay?
There is some merit to Brian's suggestion that somebody, if we're going to require membership, we should require membership at the start of the term through the duration of the term. That being the case, at some point in time, if we're going to make the state association responsible for the memberships of their elected or appointed delegates, it's just a question of when do you do that. I could live with Brian's suggestion that says they have to do that at the time they appoint them. They have to make sure their membership is current through at least December 31st of that year. I could live with we just do it during the year. Either does not strike me as an undue hardship for the office.
Yeah, I would suggest if we approve this, that for now, they do it when it expires and maybe starting next year with names, just to give the states time to realize what's going on.
But I think it should apply to their membership status at the beginning of their term. I don't think people should get the idea, oh good, I'm going to expire, I don't have to pay, let the state pay. I don't think that's something that we want.
Well then, well no.
Instead, I think those people should say, I have to pay, otherwise.
All right, we need to take this vote and move because there's other stuff. All in favor of Mike's idea, raise your hand. Abstain? Well, Mike, you don't have a majority vote. All against, raise your hand. 1, 2, 3, 4, 5, 6, I think. You got a lot of abstentions. 7. What do you got? 5. 12. All abstaining. 1, 2, 3, 4. What do you got? 7.
We should do one in favor.
1 in favor.
One in
No.
favor.
Correct. That's correct.
Mike, you didn't vote in favor.
I'm not voting on anything at this meeting, I'm staff.
Okay. Now, the next one is really simple. I don't think we need any discussion. Article 5, Section 5 has 2 things called Part B. We're proposing to correct that and label them correctly.
Part B, part of the other B.
You go to 13 on bylaws. Can I simply call for a vote?
Harold, we haven't voted on the last one. We voted on the 28 versus
We
0.
only voted specifically on the 28-day grace period and
All right.
a failed attempt to make the state chapters responsible.
Yeah, all right. I assume when we voted on the 28 grace, it was in favor. 11-16 with the 28-day grace period, except you must be a member at the start of the delegates. 28 days grace doesn't apply. All in favor? 1, thank you. 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13 on this side.
13 on this side.
Okay.
I really am counting them. I'm not just taking your count yet.
Opposed? 1. Abstain? 1, 2. All right, so thank you guys for pointing that out. All right. We're trying to just label the sections correctly. Can we just proceed to a vote? All those in favor? Raise your hand. 1, 2, 3, 4, 5, 6.
Raise your hand.
B, changing B to C.
I'd like to label the sections correctly so we don't have 2 sections B. All right, let's start again. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13 on this side. 14. 14. All those opposed?
Now we see how accountants do it.
I'm just not going to vote next time.
All right. I'm hoping some of these others are going to go fast. ADM 1113, page 17. We had 2 ADMs currently that deal with US and FIDE. They were both put in to certain circumstances going on in FIDE. John McCrary, who was, I think, the author of both, agreed to look at that. and come up with just keeping what seems to be applicable now. And that's what we have in 1113 on page 17. Because there's no election going on immediately. And this simply repeats the fact that we endorse principles of free action and freedom of speech. We oppose any regulation that limits journalistic freedom.
We've got to get this out of the bylaws and into DACIs, that's why we want that.
Can I make a technical point here?
Sure.
Before we go into the substance of this, I do not understand how we can start treating DACI as a code which is going to be amended. The DACI is simply a list of motions that someone put together as motions, as motions that are of continuing interest.
Right.
The delegates, I've never been in a delegates meeting before, but as I understand it, the delegates do not designate motions as being.
Sometimes they do now. Yeah, in recent years they have.
Well, they should stop. They should stop. It doesn't make any sense. And if we're now going to start having motions to amend the DACI, that makes even less sense. I don't see any problem with having a motion where someone we pass the delegates to pass a new motion. But if we start adopting motions to amend other motions that were adopted by the delegates in previous years, because those motions have been designated as DACI, then I don't understand what the DACI is, and that doesn't make any sense.
Bill Hall has his hand up. You want me to go first, Bill?
Well, we may be about to say the same thing. Illinois Council, our council, has said that they think at least there's a very credible argument, if it's not definitive, that the DACIs are essentially part of the bylaws.
No. Well, let me phrase it a different way.
That's part of the problem. No one ever took a vote to do that.
Hold it. Hold it. I don't necessarily agree with that, but we wanted both the office and the executive board to know what resolutions were still in effect that could govern their actions. B, there will be wording on the floor from GTF, taking out wording from the Illinois State Bar Association that says specifically, there they have what they call an assembly, and a second body called the Board of Governors. The governors is like our directors. But it says specifically there, the Board of Governors must follow mandates of the assembly. And the idea of this is a place to put those mandates in, so both the office and the executive board knows what's been ruled on certain issues. And if they don't like it, they come to the delegates meeting the next year and try to bring change.
Harold, those are called minutes. And if we had minutes, then we wouldn't need this sort of DACI.
Well, we have minutes, and I have a collection at home, and Mike Nolan is doing a great job of getting those minutes on the website back to, 2003 to 1998?
I did have to back to 99. There's 2001 or 2002 will be out there in the next day or two.
But I don't want to have to bring my set of minutes back to 1975 to every meeting, and the office doesn't want to have to bring its set to every annual meeting. So the idea is we want to catch what is something that would have a continuing effect and put it for people to see.
Then there should be a motion in front of the delegates adopting the DACI as a code of standing rules or something, or some term like that. And then it starts making sense. And we should adopt the DACI.
I want to make a motion, but it's 10:16, and I wanted to clear up all this stuff.
Until we've done that, it's not a code, and it doesn't make sense to start to adopt a motion.
I guess I respectfully disagree, because if you read the bylaws, the executive board can act contrary to actions of delegates. That's the current way it works. Are we dealing with a specific motion? No. Because I don't know what the general stuff.
And I have to agree with Brian here that the delegate actions of continuing interest are nothing less than a subset of all of the motions that the delegates have passed over the year, some of which are still in effect, some of which have been mooted by time or circumstance. To say that this particular list of 38 or 42 or 63 or whatever the hell there are today is more important than the rest is ludicrous. They're all equally important. It's just a sum we have chosen for propinquity rather than anything else to highlight, more as a reminder of anything to the delegates that, yes, we've already said something about this. You know, these are the policies we decided to repeat in the delegates call every year. All of the other policies that are still in effect, and many of these over the years have applied specifically to publications, and as you may recall, on 2 or 3 different occasions, we've gone through and said we're either going to list all the publications mandates by the delegates, or we're going to delete them all, and we've actually done both of those several times. They're all still in effect. What there ought to be is what amounts to the equivalent of the U.S. Code, which is a list of all the delegates' mandates going back as far as we possibly can.
Put all on the website.
I'm sorry, just putting the minutes on the website does not codify it.
No,
it does not make things clear. It
misunderstood.
does not clear as to which ones are still in effect, which ones have been superseded, which ones
Of course it doesn't, but then you can analyze that and make the list you want once they're on.
Great, then I...
Look, I have specific items.
Right. I think there has to be a mandate to somebody to do that work.
Okay, I'm willing to come back to this.
I probably will.
At the end of the meeting, if we have time, but we need to deal with the specific items that are going to come up on Saturday. Very short, quickly, Byron and Ken.
This whole discussion points to the real solution, that is, once you can get a reasonably complete list of minutes going all back as far as you can, then all of a sudden it becomes searchable.
Yes, that was my
And you
point.
can put,
That was my point.
you can look at the topic you're considering and you'll see all the motions that,
Yes.
that came up to address it.
Including the ones that repeal earlier motions. Wait a minute. Ken, and then we're moving on to the specifics. We'll come back at the end of this.
And it's
Otherwise,
opened
we're
up
gonna-
a huge can of worms, but I think all Brian is asking for, and all I've asked for in the past, is that we simply stop referring to the BACIs as if it is something important. We just stop doing that, we've handled the current issue.
Come back to this after the meeting. Come on, we've got to get through this.
Well, again,
We really have to. Come on, we're on 11 through 13, the FIDE stuff. I heard exactly 0 discussion of it. Can we proceed to a vote? Hearing no objection, all those in favor, please vote. 9 on this side. 10.
Well,
That makes 22 on my count. Hey, we got different numbers. Opposed? 1, 2. Abstained? 1, 2, 3, 4, 5, 6, 7. Okay, I apologize for cutting things short, but we need to get to the governance stuff. Okay, ADM 1118, page 18. Hopefully this is simple too. We used to have count the votes for the executive board right here at the annual meetings. We had tellers, they'd open the ballots. There was a procedure there. We have not done that for years. Instead, the count, Mr. Sabine has supervised it somewhere in Crossville, I believe. And we don't have any of these problems. So our thought was, why not get rid of this because we want to take anything unnecessary out? Anyone want to speak against it? Hearing none, all those in favor of ADM 1118, please raise your hand. 1, 2, 3, 4, 5, 6, 7, 9 on this side.
15.
Oh, 24. Opposed? Abstentions? 1, 2, 3, 4, 5, 6. All right, I apologize for screwing up with some of these things. Easy. All right, hopefully this is too. ADM 1118, page 18, simply puts together in one place 2 different things about the US. 1119, you're right. Did I screw that up?
yes. Okay,
I got it. Oh boy, I got all my numbers wrong. Now I probably get the next one wrong too. Simply puts in one place 2 different sentences on the US Open. Again, it's simpler to have them both together. There's no real controversy, just 2 abstentions. Can we proceed to a vote? Hearing no objection, all those in favor, please. 9.
15.
Oh, 24. All opposed, raise your hand. Abstained, raise your hand. 1. 11, probably got the wrong number again.
20.
1120 on rating list. This was Alan's pointing this out. There are again 2 different things on the rating list. special occasion, a tournament has a special demand, the office will honor it, but we don't want to mislead people, and that's the reason we want to do that, simplify. Hearing no discussion, all in favor, please raise your hand. What do we got?
16.
Oh, we did the biggest vote yet. Opposed? Abstentions? All right. Now, 30, we have some things here that on substance aren't strictly bylaws, but their wording involves the bylaws. The first is this thing about armed forces personnel, 1124. He wants to provide the same membership discount as premium and regular young adult membership. So we came up with wording that tracked bylaws, and I'm trying to figure out, do you have that wording handy? I have to look
Are you
for
talking about ADM 1130?
24.
Yeah, I thought I heard it.
It's a bylaws amendment because it changes.
I don't know what your number 30 is up there then.
That's just the 30th. Okay, right. Explanation. These would be ordered votes
Okay.
the bylaws committee took, and the earlier numbers are when we go back to the GTF. It's 1124 on page 19. If you want me to find the wording, I can. It basically tracks the wording on the bylaws. Dues is wording, do is the way it was written. You can save time, you can trust us if that's what we've done. It's just a technical amendment. Can we vote on that, or do you want me to get out for it? I'm saying this just because time is really running. It's 10:24. Not hearing requests for the wording, all in favor of making the wording conform to the dues wording and the rest of the bylaws, raise your hand. 1, 2, 3, 4, 5, 6, 7, 8, 9, 23. All those opposed? 1, 2. Abstentions? 1, 2, 3, 4. 4. Okay, now, on the substance of the matter, since this is a dues issue, we voted 9 to defer to finance, because usually we don't deal with substance of an issue if it's another committee's jurisdiction. 1 in favor, 2 against, 1 abstain. So we are proposing that this workshop not take a stand on the substance, but agree to defer to the finance committee because it's a dues issue.
But if the name passes, if you need to clean the language up.
Yeah, well, we'll clean the language first on the floor.
There is a
Yes.
there is a bylaws issue here, which is why are the dues in the bylaws hideous?
And I hate to be terrible about this, but I don't think, again, we can go back at the end of the meeting if there's time, because the delegates have wanted it there so they can control it. And that is
Otherwise, the
that's the
executive
simple
board
action.
could change the dues as a wish.
Well, what about the BACI?
Okay, but again, wait a minute. I'm going to have to approve it. This isn't to be issue is, are we agreeing to defer to substance to the finance committee, or do you want to vote on substance?
Where is the appropriate point to discuss my plan?
At the end of the meeting, if we get to it, because we're dealing with specific proposals that are on the agenda, and we have a limited amount of time, which is running very rapidly at 10:26. All those in favor of deferring to finance and substance, raise your hand. 1, 2, 3, 4, 5, 6. I'm sorry. 10.
16.
Opposed? Abstentions? 1, 2, 3, 4. Now 1128. This is 7 Ryan's proposal about scholastic newsletter.
No, that's being
Just
withdrawn.
like the kids withdrawn.
That's being withdrawn.
Great. In order to defer to scholastic.
Boy, I just made him real happy.
All right.
Maybe I'll put it back in.
1146. That is
Well, actually,
matter for this group. There were 2 points in it. Again, I
26,
can't
27,
remember
28,
if you like.
that's what we talked about.
Says the executive board shall not initiate any lawsuit against the Foreign National Chess Federation or against FIDE without approval of the board of delegates. Our technical amendment, which I'll, if it could save time not to read, simply says that, however, you're free to file a counterclaim. If it doesn't bar a counterclaim, FIDE or Foreign Chess Federation Suit. And then on the substance, as you see, we weren't pleased with this and we voted against it. So if you'll accept my wording and that what the counterclaim says, because it seems to me that's fair. All in favor of the technical amendment without a counterclaim, please raise your hand.
Which number was this again, Harold?
46.
Thank you.
This is 46. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11,
15.
26. All opposed, raise your hand. Abstentions? It's got to be some. 1, 2, 3. Now, on the substance, we felt situations came up that the executive board has to act, and we have to rely on their good judgment if they feel a lawsuit should be initiated, because sometimes it has to be done in a certain amount of time. And you can't wait until the delegates meeting next August, and that's why we voted that down. Is there discussion? Because we take this vote and then we can go to the second part.
Does this would include entering into arbitration cases?
Gary, any opinion on that one?
Well, there's no real difference with respect to litigation or arbitration. I mean, some arbitration is often contractually required, but in terms of legal fees and things that would normally concern the delegates, it will not make a difference. So arbitration and other, we should put an alternative dispute resolution provision in there probably if we want this to be all encompassing. But I think we could probably deal with this question by getting to the vote.
Yeah. Okay, so let's assume it does include arbitration. Can we vote on the substance of this as time runs out on 10:29? All those in favor of what they are proposing to so restrict the executive board, raise your hand. 1, 2, 3, 4, 6.
There were 3 on that.
Yeah, 6. All opposed, raise your hand. 1, 2, 3, 4, 5, 6, 7, 8, 9. I got 9 here. 10.
12.
Abstentions. 1,
2 on my side.
and 1 on here. All right, we just made it by 10:30.
I would point out that we did not talk about, for this specific reason, either ADM 1121 or its twin ADM 1140. It's the same thing in their class.
Oh.
Because that was dealt with in the Rules Committee, and it's going to be handled under one of the other ones. So I think in keeping it out of the bylaws, it's going to end up in rules alone. Is that right, Richard?
Oh, well, there's actually 3, and we're going to bring one on the floor, and then we're going to submit it as a bylaw change, but we had to make basically
But the thought process that came out of rules was to make rules changes require 2/3 vote.
That's correct. That's correct.
Just from the get-go, not things that come up before. And the purpose behind it is exactly what the rationale says. And the Rules Committee had the same thought.
The Rules Committee accepted the just flat 2/3 as well as did the workshop.
So that's going to occur, and we kind of kicked it over to rules, and that's where they can. Okay. ADM 1122, and then by extension 1123.
No, we take 22 and 23 together.
Well, they're not together.
No, I was going to withdraw 1123 because I only submitted.
I thought that was the case.
Right.
Okay.
Yeah. Brian submitted to make sure that we did something. And to shorten that up, so we did something. I chaired the GTF task force after Joe Lutz decided he didn't want to. Last year I presented the GTF proposals because Joe wasn't going to be able to come to me. So I figured if I was dumb enough to do that once, I was dumb enough to do it twice. So after we were looking for a chair, I stepped up in mid-April, and we moved as quickly as we could to the conclusion. Pretty much everybody on the GTF is listed as a sponsor of this proposal, with the exception of David Quinn and Mr. Winston. What we are attempting to do, in essence, is clear up this question of who is the board of directors of the organization. We are in this series of proposals. A lot of it is technical stuff of saying directors and delegates, because right now it just says directors, which encompasses everybody. The whole last half of it is really more technical provisions than anything else. The first two sections to me are the most, first 2 or 3 sections are the most important ones that we dealt with. And the whole attempt behind this is to establish clearly that the executive board is the legal board of directors of the corporation. Why? Keeping the powers that the delegates presently have in the hands of the delegates. So, the proposal retains the power of the delegates to amend the bylaws, approve the rules. We're making some changes and approve the budget, appoint its committees, which is the powers that they have now, by and large. We do have some changes. Cheryl, can I get you to pass? Would you mind if you pass these out?
Oh.
I think I've got a copy for everybody here. I would have to, no, there should be 40, and we have 36. One of the problems is finding a way to do this, make it fit with what we do, and make it fit with Illinois law. I think it's fair to say that the GTF struggled with some of our language, amending the articles that deal with the rights and responsibilities of the EB and the rights and responsibilities of the Assembly of Delegates, Board of Delegates. And we struggle with that language a bit. We're proposing to change the language a little bit that's in this ADM. And we're handing that out now. We went and looked at the Illinois Bar Association, which has a similar structure to ours. The Illinois Bar Association has a Board of Governors, which has 27 members, and then it has an assembly, which has 150 or 160. So what I will propose as an amendment to this language that is in the ADM. Article 5, Section 1 presently says, the Board of Delegates is responsible for the management of the USCF, which will formulate general policy, adopt the annual budget, and write the bylaws. That's what Section 1 says that the Board of Delegates is to do. We have clarified, we have language in the ADM that says the Board of Delegates shall formulate general policy under the bylaws, approve the annual budget, amend the bylaws and the official rules of chess, and supervise the ethics and compliance process of the Federation. After looking at the Illinois Bar, modified that just a smidge to clarify that the legislating and the governing body of the USCF shall be the Board of Delegates. The Board of Delegates shall be the supreme authoritative body of this association, shall determine the policies that govern the USCF and all its activities. Among other things, it shall have the authority to amend the Articles of Incorporation. It was pointed out to me that we had left that out. There was a drafting error. The bylaws and the USCF official rules of chess, approve the annual budget, and supervise the ethics and compliance process of the Federation. Presently, ethics cases can be appealed all the way from delegates. Yes.
Do you need to include the code of conduct, or is that separate? Is that separate from the rules of chess?
I think it's...
Then it probably ought to be out.
That's part of the ethics and compliance process of the Federation.
Yeah, I think you need to at least mention the code of conduct that they're responsible for maintaining it.
I don't have a problem with that. I think they do
It's
now.
a minor issue, but I think it's one you should put it up.
Yes.
One observation that came from, I think it comes from rules, is that possibly the next rule book will not be called the USCF Official Rules of Chess 6th edition.
I think we cross that bridge when we get there, because that's what we call it today. I appreciate that problem, and we may have to change the wording of it. in and look at the EVs. Presently, the language says that executive board shall manage the affairs of the Federation, including employment and other contracts, between meetings of the Board of Delegates, and shall perform other duties as specified in these bylaws. The executive board shall be subject to the authority of the Board of Delegates, and none of its acts shall conflict with actions taken by the Board of Delegates. The executive board's directions to the staff shall generally be given by the USCF president. The language that the GTF came up with, and this was largely a three-way discussion, honestly, with Gary and Brian and I. And I think when we got done, I don't want to speak for you two guys, but I think when we got done, we were not perfectly satisfied with the language that we got. I mean, we were struggling with some pieces of it. We came up with and submitted as part of the ABM, the executive board shall be the administrative and managing body of the USCF and possessed with full power to conduct all business of the Federation, subject to the laws of the state of Illinois, the Articles of Incorporation, bylaws, and the mandates of the Board of Delegates. I'm sorry, that's what we're talking about. Here, I'm sorry. What we came up with the ABM is the executive board shall direct of and be the board of directors of the Federation, and shall manage the Federation's affairs, giving due priority to the missions, goals, and policies established by the Board of Delegates according to these bylaws. We weren't real sure what due priority meant. What we were trying to get to is they got followed. So the revised language based on the Illinois Bar Association is what I read the first time. I'm sorry for confusing you. The executive board shall be the administrative and managing body of USCF, vested with full power to conduct all business of the Federation subject to the laws, the state of Illinois Articles of Incorporation, bylaws, and mandates of the Board of Delegates. And I think that solves some of Harold's problems with the approach.
It solves one big problem, yes.
Yeah. Not all of them, but a big one. Which was the idea of establishing that in some way the executive board had to listen to the delegates. Now, my point of view on this is that the delegates control the bylaws and control rules. And if the board has to act in connection with the bylaws, they got to pretty much follow the damn bylaws. If the board doesn't follow the bylaws today, or at some point in the future the board doesn't follow the bylaws, there is recourse to deal with that. Either sue board members, I hate saying that word, but you can. If they have not followed the bylaws, that's a recourse. You can recall them. But once an egg is cracked, it's cracked. And that happens today. I mean, if the board Sunday afternoon takes an action that the delegates don't like, the delegates are not going to be able to deal with that except by recall or suit before next August. So, from my perception, what we've done, and I know not everyone will have that perception, is try to maintain a lot of the status quo while clarifying the legal authority of the directors. Richard, you can. So, thoughts? Gerald?
Okay, so we're dropping making the executive board the board of directors from this.
No, we are not.
No, that's probably
We're not stating it.
We're not stating that. That was going to be my point. I think that the changes could be more consistent with the Illinois Bar Association wording are okay. Except the striking thing that I notice is we have not made the executive board the board of directors. Given that the board of delegates is currently the board of directors, we have to have wording that states very explicitly that that is going to change. Because otherwise, anyone would go to court and say the board of delegates is still the board of directors. They never passed any change anything to change that.
I understand.
Right. So I would suggest that the language be the executive board shall be the board of directors of the USCF and shall have and shall be the administrative and managing body of the USCF.
Shall be the board of directors and the administrative and managing body of the USCF. There you go.
Rather than and, how about make
That's good, yeah, I like that. Because then, by doing that, we drag in the statutes and all of the case law as to what the powers of the board of directors are.
Beatrice, you had.
I have a question. What is the, what are the reasons for making this change? Because up to now, we never had a problem with the bylaws as they are.
Anybody want to address that issue? I mean, Bill, I think, I'm asking, I think there's some people on the floor who have opinion.
By a vote of 8-0 from the committee of all former USCF corporate attorneys, they say we are insane with having this structure. Plain and simple. You can't have 150 directors of a corporation. Every single one of them, when I tell them that is the situation, they laugh at me and they say, are you serious? And I say, look at our bylaws. They don't believe me at first. And the reason the Bar Association thing doesn't reference specifically that the smaller board is the board of directors is because it's always been that way and it's intuitively obvious, and they wouldn't be insane enough to have the larger body be the board of directors.
Sure.
It's actually even worse than that, because for large parts of the year, we can't even name who our board of directors is. And that strikes me as probably illegal.
It's problematic.
It is actually illegal under Illinois statute not to name the board of directors accurately with knowledge.
Myron?
Yeah, a little background might be in order here. Way back when, before the recent series of major bylaw changes in governance, everything was pretty clear because the board of delegates clearly was the board of directors, and in fact, at one point in time, they were called the board of directors. That was changed to avoid confusion of the word director with term director. As time passed and we had these other changes, up until that time, everything seemed clear because the executive board, and before it, the policy board, was the executive committee of the board of directors, and the delegates, in fact, voted for the executive board, the voting members. Now, all of a sudden, it's a different situation, because now you have one group, namely our existing voting members, naming the delegates and naming the executive board. Well, in a situation like that, it becomes very unclear, because you don't have a situation where a group is naming its own executive committee. So now everything does have to be redefined from a legal standpoint. There doesn't have to necessarily be any changes in function, but redefinition is essential.
Yes, Mr. Coleman.
I think Myron makes a pretty good point, and I want to highlight that the board passed a motion before I even started that the executive director can sign any contract that has a liability more than $10,000 or a year in existence, $30,000